5 seconds to go. Start. Mr. Tripurari Ray submits that the High Court and the Sessions Judge have grossly erred in convicting the appellant's accused. Stop. Mr. Ray submits that it was the deceased who trespassed into the house of the appellants and assaulted accused number 1 Lalchand since deceased. Stop. Thereafter, the appellants exercised their right of private defense and assaulted the deceased. Stop. Further, most of the injuries that were caused to the deceased one on their legs and not with an intention to cause severe harm. Stop. Para. Mr. Ray further submits that on a perusal of the dying declaration, that is, statement of deceased, it would reveal that Dr. Renu Jamwal stated that the patient was not in a condition to sign the statement due to swelling. Stop. The said statement does not state any details regarding the mental physical state of the patient, whether he is of sound mind and consciousness. Stop. Further, Dr. Renu Jamwal admitted that the patient was minimum conscious and not fully oriented to place. Stop. Para. Mr. Ray asked that the evidence of PW1 and PW3 contradict the dying declaration on several points. Stop. The dying declaration does not state that PW1 was assaulted and confined in the house of the appellants, which is why both the deceased went to the house of the appellants. Instead, it just states that they were finishing their work and were assaulted by the appellants. Stop. Para. Mr. Shailesh, appearing on behalf of the respondent state, submits that the Sessions Judge and High Court have concurrently held that dying declaration is a substantive piece of evidence. Stop. The same is attested by PWSI and Dr. Renu Jamwal. Stop. It is also corroborated by the evidence of the PW1 and PW2. Stop. Thus, it cannot be simply brushed aside. Stop. Para. He further submitted that the right of private defense should be exercised in a reasonable manner. Stop. The nature of injuries would reveal multiple fractures and the weapons used would indicate that the appellants assaulted the deceased with the intention to kill them. Stop. Para. We have perused the materials placed on record. Stop. From the materials placed on record, particularly, the post-mortem report, it cannot be disputed that the death of the deceased was homicidal. Stop. Para. Insofar as the incident is concerned, the prosecution mainly relies on the dying declaration of deceased as well as the oral testimony of PW1, the brother of deceased, and PW2. Stop. The dying declaration of deceased implicates accused number 1 Lalchand since deceased as well as the accused appellants. Stop. It is to be noted that though in the dying declaration it is stated that there was no previous enmity between deceased and the accused appellants, from the evidence of PW1, it would reveal that an amount of rupees 50 was taken by accused from PW1 and the dispute was with regard to non-payment of the same. Stop. Para. Though PW1 states that he went to village Jagatpur to fetch labourers and the accused appellants caught him and started beating him and thereafter tied him and confined him in a veranda, there is no mention with regard to the same in the dying declaration of deceased. Stop. PW1 states in his evidence that after some time, when his brothers were going in the lane abutting the house of accused persons, the accused persons assaulted them with darat and iron rod. Stop. According to him, when they, on account of injuries, became unconscious, the accused persons dragged them into the house. Stop. He states that he untied the rope and managed to escape. Stop.